Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more. One of our friends on the show here is a fellow who has been involved in the Second Amendment battle for many, many years. He is a law professor. He's a Second Amendment activist, civil rights activist, actually, when you talk about the kind of cases he takes. Don Kilmer joins us right now. You will have read a lot of his work on various briefs and decisions, and he's argued cases before, I believe, the Ninth Circuit at the very least, right, Don?
Yep, Ninth Circuit, plenty.
Wait, try it again. I lost you there.
Oh, plenty of arguments before the Ninth Circuit.
Oh, okay, good deal. All right, so I wanted to get your take on a couple of things. We'll talk about the upcoming Bruen case out of New York in a second, but there's some interesting stuff coming out of Hawaii. I was wondering if you wanted to kind of weigh in and bring us up to speed on what's going on there.
Yeah, I just finished filing an amicus brief in a case called Yukatake versus Hawaii, where what was happening is that the government of Hawaii was setting up these almost like an obstacle course to try and get a permit to purchase a handgun. You had to go to the police department and get a background check. Once you were cleared on a background check to go purchase the gun, you only had 10 days to purchase the gun. And then after you purchased the gun, you had to go back to the police station, and the police station had to inspect the weapon and the serial number. And if you missed any deadlines, you had to start over. So it was clearly almost like a gauntlet of hoops you had to jump through. And all of this was on top of having to pass a regular background check and filling out a 4473 from an FFL.
And this wasn't to carry a gun. This was just to buy a handgun.
This was just to buy a handgun. Now, one interesting fact was that the state of Hawaii does have a permit that allows you to pass a background check to buy a long gun that's good for a year. It's not, you don't have to do it for every purchase, but you have to do it every year. But they didn't have that process for handguns. They made you do it every time you wanted to buy a handgun.
Interesting. Well, I mean, and you know, Hawaii has probably been the most repressive regime, if you will, or government in terms of Second Amendment rights throughout the entire country. I mean, people think of Massachusetts and Connecticut and California, but really Hawaii has been more repressive than those.
You know what? The people of New Jersey might arm wrestle you for that one.
Well, yeah, okay. And who wants to be in that race, right?
Yeah, nobody does. What interesting fact is that when Hawaii was admitted to the Union in my lifetime, and yours too, I think, but I don't want to speak for you.
Yes, indeed.
It adopted the exact same text as the Second Amendment to the United States Constitution in its state constitution.
Interesting. Huh.
Yeah.
But they ignore that.
The same place. They literally just cut and pasted it from the U.S. Constitution to their state constitution.
Fascinating.
So it's pretty tough for the state of Hawaii to argue that the right is different in Hawaii than it would be in, say, I don't know, Idaho or Missouri.
Right. And in Hawaii falls within the Ninth Circuit, does it not?
Yeah, unfortunately, too many states fall within the Ninth Circuit. You can put me down on the list of people who thinks the Ninth Circuit ought to be broke up.
Okay, but we did just have a pretty good ruling, at least out of a 3-judge panel in the Ninth Circuit regarding 18, 19, and 20-year-olds being able to buy rifles. Yes,
we did. The court recognized that it's kind of the same old argument that gave us the, I can't remember, is it the 25th or 24th Amendment, that, look, if 18-year-olds are mature enough to be handed a rifle and go fight wars, they're mature enough to vote. Well, the same argument was sort of made in the Ninth Circuit case that look, 18 and 19-year-olds can vote. They can engage in all kinds of adult activities. Why can't they purchase a rifle or what have you? So good result there. But of course, The Ninth Circuit has its own rules on the Second Amendment. They use a procedure called en banc review, oftentimes to have the entire court re-review a three-judge panel decision. So until we get out past the deadline for en banc review to be invoked, that decision is really not safe.
It's really not time to uncork the champagne yet, and I know that decision was just used in a filing in Florida because trying to undo a similar law in Florida. But overall, Don, it seems to me, having to watch this for a long time, that we are really making progress over the last 10, 15 years, and almost all of that coming, well, putting aside the constitutional carry or permitless carry movement, but most of the advances seem to be coming in the courts rather than in the legislatures or in Congress.
Yeah, I think it's a bit of a mixed bag, but you could be right. I mean, I think the most important takeaway from the court decisions is that most of the courts, maybe excepting the Ninth Circuit, but most of the courts are now treating the right to keep and bear arms as a normal, ordinary constitutional right, and they're adjudicating the cases as if it was like the First Amendment or like your right to be free from unreasonable search and seizure. They're taking it seriously, whereas a generation ago there was a judicial philosophy, if you will, or a judicial attitude that the Second Amendment was an anachronism. It really didn't mean anything. It was connected to malicious service. But Heller and McDonald kind of swept all that aside. And kudos to all the legal scholars and lawyers who came before me who helped set that up. But it's now being treated as an ordinary right. And that's, I think, the greatest victory that we've had in the courts, is that the courts are taking it seriously.
Oh, well, that's a perfect spot for me to take a quick break. When we come back, let's pick up what we think is going to be coming from the U.S. Supreme Court. Of course, Justice Clarence Thomas kept saying, we have to stop treating the Second Amendment as a disfavored right. And now they have a chance to make a decision, and at least one person has said this decision that we'll be getting in the next few weeks could be the Holy Grail. We'll talk with Don Kilmer on the backside. He can give us the legal scholar's opinion on this. Our number is 866-TALK-GUN. We're talking with Don Kilmer. He is a Second Amendment scholar, a lawyer, a law professor, been at this a long time. He's also a gun guy, a real gun guy. Don, as we're looking at this case coming out of Supreme Court within weeks now, the Bruen case, New York State Rifle and Pistol Association case, you want to kind of give the synopsis of the case, what it's about, and then kind of we can talk about it?
Sure. The case revolves around the second half of the right to keep and bear. I mean, some people, I'm in the camp that says Heller and McDonald were pretty clear that the right to keep and bear arms was affirmed by the Supreme Court as enforceable against the federal government and the states. But some people who like to parse words and shave points decided that they were going to parse that out and say, well, Heller and McDonald really only upheld the right to keep a gun in your home, but didn't uphold the right to bear a gun or carry a gun in public. So several cases tried to plug that hole. I was involved in an effort in California with the great Alan Gura, who won Heller and McDonald. There was a case called Peruta versus San Diego, and the Ninth Circuit shot us down on that. Well, New York Rifle and Pistol versus Bruen is taking another run at it in the Second Circuit, and the Supreme Court has decided to hear it. Essentially, the case it comes down to this: nobody would take seriously the restriction on your right to worship or your right to speak or your right to print as embodied in the First Amendment and say, but you can only do that from your home, or you can only do it in a church, or you can only do it in a newspaper office or something like that. I mean,
you could only do it if you have a good cause, a good reason to.
Exactly, and that's the hook that the government, who've been defying the Second Amendment and the Supreme Court has been using. They've been saying, well, you have to have a license to carry. Now, the Supreme Court did give some language in Heller that it was appropriate to regulate the right. For instance, do a background check on somebody, make sure that they're not haven't had a mental health episode, or they're not a convicted felon. before you give them a permit to carry a gun. But pretty much the court's attitude was it should be like a driver's license. If you can demonstrate minimum competence and pass the test, you should get your license to carry, just like you get your license to drive a car. Of course, one big difference is the right to keep and bear arms is actually in the Constitution, and your right to drive a car isn't.
Right.
That's what Bruen is about, basically, is that can the state impose such onerous restrictions on a fundamental right, like bearing arms in public for self-defense, that actually results in nobody getting a permit at all? And the way they do that is
right. In case in point, in New York, you have to show that you have proper cause. And the way it has manifested itself is if you have given the police enough money, or if you are well connected, or if you're offering Rolexes or bribes, you can get the permit. And regular people cannot, regardless of where they live and where they work and the conditions there or the threats and risks that they encounter. And so, like you say, no one would say you could have to show good cause, to exercise your First Amendment rights.
Right. I mean, the practical effect was if you were an A-list celebrity and you'd won an Oscar or something like that, and you said, "Listen, if there are people, I have fans who stalk me," you would get a permit to carry a gun. But if you were just some ordinary Joe who maybe works late at night, maybe you run a jewelry shop, or maybe you collect cash at ATM machines, well, you need to kind of take your chances with the rest of the population. So the good cause statement is just a barrier to exercising a fundamental right.
Okay, well, let's fast forward through it because I'm going to run out of time. I know we're going to have fun with this, but the Supreme Court took the case, heard the case. We have a different Supreme Court now than we did before, thanks to Donald Trump. And I got my fingers crossed. I'm hoping that Clarence Thomas writes the decision. But reading the tea leaves, and when you heard the case being argued, it sounded as though the court really wanted to make some changes here.
Yeah, I think they do. That obviously, the primary issue before the court is can the state require something more than just self-defense as good cause? And that's the way the case is framed. That all you should have to put for your good cause on a statement is, well, I want to exercise the right of self-defense. But the holy grail, or to use your phrase, or the home run in this case is going to be if the court actually provides instructions to the lower courts on how they're to adjudicate Second Amendment claims. Are they to apply text, history, and tradition? Are they to apply some form of heightened scrutiny? Or maybe take a page out of the First Amendment and say, no, do it this way.
Okay, so theoretically, and quite possibly, we could get a decision that simply changes the way that all courts look at the Second Amendment.
Yes, that would be my preference. It should. I mean, it's a fundamental right for everybody in the country. It's in the U.S. Constitution, and it should be uniformly applied.
So it'll be a few weeks. We get this decision. Several scholars or people that know this stuff say, look, don't expect the home run. Expect it to be parsed or somewhat marginalized because the court doesn't like to make those big sweeping decisions. What do you think?
I think it's going to depend upon who's writing the decision. If it is Thomas, and I fervently hope that it is, he has dissented from the denial of petitions for review on several Supreme Court cases, and he has specifically pointed out where the lower courts were making mistakes. So if Thomas is the primary author of the opinion, I think we can look for some of the marginalia that you might find on your law school exam from a professor that says, this is where you made the mistake, don't make it again.
Well, we hope that is the case, and it could really change. Because if that happens, then the licensing schemes in 8 or 9 states is going to fall by the wayside, places that require you to show that you are worthy of exercising a constitutional right.
Yeah, there's a handful of states, 5 or 6, maybe 7, that still impose this requirement that you prove that your life is more valuable than the people we're giving permits to. And they're probably going to have to make some adjustments to their statute.
And I know that there are other cases that are trying to get their way up to the Supreme Court while we have this current makeup, the Donald Trump makeup, if you will. Any thoughts on those cases, or what we'll be looking at over the next couple of years?
Yeah, I mean, again, it's going to depend upon how broad or narrow the ruling is in Bruen. If it's a little bit broader and it gives us a mechanism or a cheat sheet or cliff notes for the lower courts on how to adjudicate cases, then that may be actually resolve quite a few cases. The circuit courts will have to backtrack and fix the mistakes that they made. It'll mean that a lot of cases.
Well, we will keep our fingers crossed. Don, I appreciate your time. We'll get you back on here after we get the decision out of the Supreme Court. Don Kilmer, tell people where they can read what you're doing or what you're up to.
Just keep an eye on cases in the Ninth Circuit and cases now in Idaho where I live. And
all right, we'll do that.